The petition has been filed to quash an FIR in crime number 9 of 2020 registered for the offences under sections 409, 506 subclass 1 IPC. It is alleged in the complaint that the petitioners are known to the second respondent / de facto complainant, that the first petitioner entered into a lease with the second respondent on 19/2/2012 in respect of the land and building belonging to the second respondent herein, that the petitioners promised to deliver the property in as is where is condition after the expiry of the lease period, that the lease was originally granted for a period of 6 years from 19/2/2012, that on the expiry of lease period the second respondent / de facto complainant found that the petitioners had damaged the building and other electrical equipments, that when the de facto complainant asked the petitioners to rectify the same, they had promised to repair and rectify the damages to the building and the electrical equipments, that based on the said representation the de facto complainant / second respondent renewed the lease for the further period of the 11 months from 25/7/2018, that from 1/5/2019 the petitioners did not pay rent to the premises, that when the second respondent met them on 25/5/2019 the petitioners promised to vacate the premises and promised to hand over the premises in the same condition as it was when handed over to them, that on 5/11/2019 the respondent inspected the premises and found that the electrical panels, cable wires, expensive switches and bulbs to the value of rupees 30 lakhs rupees 30 lakhs only were missing, that the petitioners had damaged the premises and the estimated loss on account of the said damages worked out to rupees 60 lakhs rupees 60 lakhs only, that the petitioners promised to rectify all the defects and they did not do so, that on 23/2020 the second respondent met the first and second petitioners / A1 and A2 again and asked as to when they would rectify the same. The first and second petitioners had abused them in filthy language, that they stated they can talk only through the third petitioner who had introduced the petitioners to the second respondent. The aforesaid complaint was lodged on 8/6/2020 and the first information report was registered on 24/8/2020. Mr. K.P. Anandakrishna, the learned counsel for the petitioners, submitted that the lease agreement was entered into between the first petitioner and the second respondent / de facto complainant. The second petitioner is the wife of the first petitioner. The third petitioner (A3) mediated between the petitioners (A1 and A2) and the second respondent / de facto complainant at the beginning of lease. Hence, the learned counsel for the petitioners submitted that the second and the third petitioners had nothing to do with the alleged offences, even if all the allegations are accepted to be true. The reading of the allegations would show that a landlord-tenant dispute is sought to be projected as a case of criminal breach of trust and criminal intimidation. The primary grievance of the second respondent is that the premises was damaged, hence the petitioners had caused huge loss to the second respondent. This would not constitute the offence of criminal breach of trust. Further, the allegations with regard to misappropriation of electrical equipments, cable wires and switches for a value of rupees 30 lakhs rupees 30 lakhs only is an afterthought. It is alleged that the said second respondent came to know of the missing of these equipments as early as on 5/11/2019, The impugned complaint was given only on 8/6/2020, belatedly as an afterthought to somehow give a criminal color to the